Should we wait for some 5-10 minutes or 5 minutes or so? There are only 13, 14 attendees.
They will join in the due course, sir.
Okay.
Around 95 people have registered. They will join in the due course. Relevant start பண்றியா?
நான் ஸ்டார்ட் பண்ணுங்க சார். ஸ்டார்ட் பண்ணலாம் சார்.
ஸ்டார்ட் பண்ணிரு. ஸ்டார்ட் பண்ணுவேன் நானு.
நீங்க ஸ்டார்ட் பண்ணுங்க.
ரெக்கார்ட் ஆன் பண்ணிரு.
பண்ணிட்டேன் சார். ஸ்டார்ட் பண்ணுங்க.
Happy evening to all of you. Welcome to today's virtual program on recent notifications and Prevention of Money Laundering Act and its impact on chartered accountants. To take us through this topic, we have with us CAPT Joy sir. On behalf of Office of SARC, we welcome you sir for today's program. Yeah, it's my privilege to introduce CAPT Joy sir, a person of great caliber and gesture. CAPT Joy is a fellow member of our Institute of Chartered Accountants of India, qualified in the year 1999 and started practicing Kochi since then. He is a commerce graduate from MG University, Kerala, a law graduate from Karnataka State Law University. He had been a faculty for direct taxes at the Ernakulam branch of the Institute of Chartered Accountants of India and other professional institutions for the past 15 years. Presently, sir is the managing partner and founder partner of the firm Mrs. P.T. Joy and Associates, a 23-year-old practicing chartered accountant firm based in Kochi with expertise in corporate audits, taxation matters, and project consultancy. Sir has contributed articles on various matters in the Hindu News Daily, the New Indian Express, Malayalam News Dailies, ICIS newsletters, online news dailies, publication of a professional organization, publication of the Kerala Chamber of Commerce and Industry, etc. Sir has spoken in more than 700 seminars, meetings, discussions of professional bodies, including FICCI, business schools, government departments, and live discussions on TV channels. Sir has authored 2 books which are published by Mrs. Bharat Law House, New Delhi. Handbook on tax deducted at source, and another book, Guide to Prohibition of Benami Property Transactions Act 1988. P.T. Joy was the chairman of the Ernakulam branch of the Institute of Chartered Accountants of India for the year 2018-19 and bagged the All India Second Best Branch Award of ICA for that particular year. He was also a co-opted member of the Professional Development Committee of ICI New Delhi for the council year 21-22. He is also a qualified insolvency professional with the Insolvency and Bankruptcy Board of India. Regularly appears before the Honorable National Company Law Tribunal for IBC matters. Presently, the Managing Committee member and Chairman of the Professional Development Committee of the Kerala Insolvency Professionals Forum. Sir also did a course on Introduction to Public Speaking from the University of Washington, United States of America, and on Inspiring and Motivating Individuals from the University of Michigan, USA. Sir has been a faculty to the Income Tax Department of India for their Officers Training Program and IRS Officers Association Training Program in Kerala. He has presented papers on various technical subjects and tax matters in CPE programs of IC and various business schools for the past 23 years in various parts of India. He has been taking part as a subject expert in live yearly union budget discussions and talk shows of the Asian News, Mathrubhumi News TV channels. Every year doing a program in the Manorama News channel by the name Ask the Expert on the day of India Union Budget. He is also appointed by the CBDT as a member of the Regional Direct Taxes Advisory Committee of the Income Tax Department of Kerala for the year 22-23. With this brief, I have great pleasure in presenting before you CAPT Joy to take us through recent notifications under PMLA and its impact on chartered accountants. Over to you, sir. PT Joy, sir.
Yeah, I am here. So, Mr. Rahman, the SARC official, and other very respected senior members, esteemed professional colleagues, greetings to you, belated greetings to you on the 75th year of the profession. In fact, I was just listening to Rahman reading the entire pages of the my profile. I thought let him read because anyway people are only just joining. Now, as far as today's subject or the topic of discussion it is concerned, Mr. Rahman, I hope I am audible and visible.
Yeah, you're audible and visible, but your bandwidth is bit low, I think.
Maybe due to the rains in Kerala, it's heavily raining in Kerala now.
Okay, okay,
In Kochi, it is heavily raining now.
okay.
So, my friends, professional colleagues, as far as the today's topic it is concerned, the subject matter of discussion it is concerned, it is the two notifications issued by the central government under the Prevention of Money Laundering Act. Now, as we look at our profession, maybe for the last 15 or 20 years, what has been happening to our profession, see, as an observer or maybe as a person, co-traveler to the profession. Now, every member who is in practice specifically, every member is speaking about maybe the manpower availability or the quality of the manpower. So, an issue that the practicing professionals that we are facing. 20 years back or 15 years back, the availability of the manpower, it was not an issue. The quality, it was not an issue. Then the price of the manpower, that was also not an issue. So there is plenty of manpower that was available. Quality, now the excellent quality manpower, it was available. And the people, they used to stick on with us, years. Now some of the people, those who are joining us, they become just like our extended family members, and they'll be with us for a number of years together and sometimes decades together. Now those days are gone now. Those days, since the manpower it is available at the cheapest possible price, we never thought of charging the clients to that extent because the cost of execution, mainly the manpower cost, it is less. So we charge it less. Now for an assignment where we employ only, let us say, the manpower which is available at an economy price, we charge it less. So in fact, see who took the benefit of this what do you call the cheapest possible manpower. I would like to say it is maybe indirectly, knowingly or unknowingly, we permitted the clients to enjoy the benefit of the cheap manpower. Now the time it has gone. Now for some of the clients, for some of the businesses, the second generation, it has come into the driving seat. For us, the manpower cost, it has gone up. Manpower cost, it has gone up. Now the technicalities, the technical complications for execution of the work, that has increased. Accountability, responsibility, it has gone up many-fold. Now the profession, now it is striving, maybe little extent now it is struggling, especially the SME practitioners. And there are multiple regulators now. And sometimes it feels like CPE, the regulators are competing. The regulators are competing to regulate our profession. There are multiple regulators. Every person who is sitting in an office, a regulator, they have a feeling that see, apart from the ICA, which has to be the exclusive regulator, we all can regulate these chartered accountants. Now the PMLA notification, two notifications, one it is on 3rd May and the other it is on 9th May. Two notifications it has come in the month of May. Now the two notifications, the what do you call the ripples created by the two notifications in the minds of the professionals, especially the practicing CS, those ripples are yet to settle down. Let me tell you, it is yet to settle down. Now let me screen share. So, my dear friends, wherever you want to raise points or ask questions or anything which I can help you to the extent of my understanding and knowledge, I am ready to help you. Please ask questions. No, please interact. I hope this is visible to you. This particular document, PDF document, it is visible to you. Can I presume
Yes, it's
that no,
very
this
much
is
Yeah,
visible?
it is visible,
So this, we are not discussing the PMLA as such. We are only discussing the two notifications, the May 3rd and 9 notifications. But for the sake of understanding, some basics, some fundamentals of the Prevention of Money Laundering Act. So it has to be there behind our mind, or maybe at the as a basis, as a prelude, it should be there. This Prevention of Money Laundering Act, maybe it looks a less magnitude, less volume document with only 50 pages, 75 sections. Now, what is interesting it is there is a schedule at the end of this particular statute. The schedule is a schedule of offenses, or could be said to be a schedule of crimes. At the end of the document, from page 41 onwards, now it is listing out certain offenses under various statutes other than PMLA. Various statutes, these crimes are called, these offenses are called scheduled offenses, which is very important for us to understand the implications of the two notifications. So this is the schedule of offenses which is listed out at the end of the PMLA statute. If you look at these offenses, these are the first part one, part A, schedule. It talks about, it lists out, it refers to offenses under the Indian Penal Code, IPC offenses. Please look at the offenses. No, we are not going to read and understand all these offenses, but please look at the nature of offenses. They are starting from criminal conspiracy under the Indian Penal Code, waging or attempting to wage a war or abetting waging of war against the government of India, conspiracy to commit offences punishable by section 121 of the IBC against the state, counterfeiting government stamp, etc., so on and so forth. Attempt to murder, attempt to commit culpable homicide, voluntarily causing hurt to extort money or to constrain to an illegal act, voluntarily causing grievances, hurt to extort, etc., offences relating to extortion. Now, the list is very huge. These are the offences under the Indian Penal Code listed out at the end of the PMLA. They call it as scheduled offences or scheduled crimes. Then it continues. Offences under the Narcotic Drugs and Psychotropic Substances Act. Now, many of the offences under that particular statute listed out. Then offences under the Explosive Substances Act listed out. Offences under the Unlawful Activities Prevention Act, we call it as UAPA, listed out. Penalty for being member of an unlawful association. Penalty for dealing with the funds of an unlawful association. Punishment for unlawful activities. Punishment for terrorist act. Punishment for making demands of radioactive substances, nuclear devices, etc., so on and so forth. And some of the offences listed out, you may get surprised. Please look at the paragraph 6. Offences under the Wildlife Protection Act 1972. Hunting of wild animals. So it is a scheduled offence. As far as PMLA it is concerned, the Enforcement Directorate can issue a notice on you if the proceeds of the offence, it is relating to an offence in the sense hunting of wild animals. Contravention of the provisions of section 17A relating to prohibition of picking, uprooting, etc. of specified plants. So this is the list of offences. So in the PMLA, this is called scheduled offences or scheduled crimes, only to make you understood that no, there is something called scheduled offences. So at the end of the PMLA statute. I hope this is clear to you. If you have any questions at this point of time, you can ask me. Otherwise, I will move on to the next part. If you want to ask me anything, no, please ask me now. Please make it interactive. Can I move on with your permission? Hello, can I move on? So let me tell you something interesting. People used to ask, why the term money laundering, just like a laundry where the clothes are whitened or dirt it is washed out. Why the term money laundering? There was a person by name. He is called Capone. His name was Alphonse Gabriel Capone in US. He was a criminal, notorious criminal. What he did was he earned a lot of money from the illicit activities, notorious crime activities, criminal activities. The money has to be converted, the tainted money, the illegal money which he earned from the notorious activities, the crimes. So he wanted those money to be converted into the legal tender money. So the tainted money, what he did was at various parts in the United States of America, it happened in the early 20th century, maybe in 1900 early, it happened. He installed laundry machines at various parts in the US, where along with the clothes, money also, the coins also could be dropped in a particular box, so that you will get the clothes washed and ironed. For let us say the coins that you dropped will be the remuneration for doing the washing and ironing and other things. So the money collected, it is a cash, it's a cash collection. So ultimately, the tainted money, the illegal money which he earned from the criminal activities, he converted into a legal money by way of installing the laundry machines. So the income earned from the laundry business, maybe if he earned, let us say, $1,000, instead of $1,000, he will be showing it as $5,000. So with the additional disclosure of the cash collected from this laundry business, he converted the tainted money into a legal money, so that this name, it is attached with this particular activity, the money laundering. Now, let me take you to one news that has appeared, some writing that has appeared in one of the newspapers. It is written by our own member, Mr. Mohan R. Levy, some 2 months back. What prompted the government to act against us all on a sudden, without any provocation, which was visible to us, to the public? We all knew that there was something called the Chinese arms. Chinese arms, we all know. See, many of the Chinese arms, there were Chinese applications available. These Chinese applications, it is used by companies, could be said to be foil companies or some shell companies. They were engaged in giving online, they were engaged in selling the online loan applications. So many chartered accountants, the government on inquiry, the government found that many chartered accountants were associated with those shell companies, which were into the business of doing the online loan activities. And it says that ultimately the data, the details collected from sale of these apps or maybe doing the loan applications, these data, apart from running the shell companies by the CAs, these data, it is sold out to certain companies who are happen to be gaming companies. So names of the certain chartered accountants were traced out by the regulators, and those names were given to the Institute of Chartered Accountants of India for initiating the penal action, the disciplinary action. Plus, what was important for the government of India was, the Ministry of Finance was, the review from the international agency, FATF, Financial Action Task Force, that was due, or that is due in November 2023. So at a time when FATF is going to come and inspect that what this government is doing against AML or PMLA activities. Now all this happened all on a sudden. This particular instance or this particular activity which has surfaced, which has come as a setback for the government of India. So which indirectly prompted the government to initiate the action. So all on a sudden, the Ministry of Finance brought in 2 notifications under the PMLA. So if you look at the PMLA, the Act, maybe some basic understanding of the Act, if you look at the Act, this is what the structure of the PMLA statute. It was, we call it as the 2002 Act, but it is made effective from applicable only from 2005. It is divided into 10 chapters, 75 sections. There are 15 rules and regulations notified, 15 rules and regulations. And there are, let us say, including the recently introduced two notifications, 3rd May and 9th May, there are around 60 plus, let us say, circulars, etc. issued. And there are two authorities. This is very important. There are two authorities. There are two authorities under the Prevention of Money Laundering Act. One, it is the Director FIU. This Director FIU is entrusted with the task of, let us say, collection and processing of financial intelligence data. Collection and processing of financial intelligence data. Directorate of Financial Intelligence Unit. The other one, it is the Director of Enforcement. As we regularly on daily basis, what we see and hear is about the Director of Enforcement. In fact, the Director of Enforcement, it is constituted not under PMLA, it is constituted under FEMA. But they have the powers. They are empowered to exercise the various powers under PMLA with respect to confiscation, arrest, punishment, etc. So mind you, the two authorities under the PMLA, one it is the Director FIU and the other one it is the Director Enforcement, which is constituted under FEMA, not under PMLA, but they have been given powers, matters with respect to matters of confiscation, arrest, punishment, etc. So the action part, it is entrusted to the Director Enforcement, but the other, what you call the less action packed or whatever the story part, that is related to the Director FIU. So the two authorities are very important. As far as the notifications are concerned, Director FIU is concerned with the notifications. Reporting entities are concerned, Director FIU is concerned with the reporting entities. If we are going to be reporting entities under the PMLA, for us, we will be interacting with, we will be dealing with only Director FIU, not Director of Enforcement. Anything that you wanted to ask me, see, friends, at this point of time? Hello, anything that you want to ask me? Now, under PMLA, there is something called a PLI, Placement, Layering and Integration. Let us say you are earning money from an activity which is called a scheduled offense. Let us say from a criminal conspiracy, somebody is earning money, maybe 1 crore Indian rupee, he is earning from a criminal conspiracy, which is a scheduled offense. Now, this money has been utilized for purchase of a property. So basically, this proceeds, it is related to an offense, which is a scheduled offense, criminal conspiracy. Money is coming into the hands of the person, the particular person, which he uses for purchase of an immoral property. Subsequent to purchase of the property, the property has been sold out. Ultimately, there is a capital gain. He pays the taxes on the capital gain. Then the money becomes a tax paid money, which he uses for starting a new business. Maybe for commencement of a company, or maybe starting a partnership business or LLP business, whatever it is. Money is invested as a capital in a business. Now, income it is generated. Ultimately, on those income that is generated, on the profit, on the taxable profits, income tax is paid, taxes are paid. So from the proceeds of a crime, now it is placed, it is layered and integrated into the normal money circulating system. This is what is called placement, layering and integration. Placement is the process of transferring the proceeds from illegal activities into the financial system in a manner not detectable by the governmental authorities. Ultimately, let us say money is originated from a scheduled offense, criminal conspiracy. There is a purchase of the property. It has been sold out. There is a capital gain that has arisen on which taxes are paid. Now the income, it is coming again, that is invested in a business. Now the business is running, profits are generated, taxes are paid. It is integrated, it is layered. Ultimately, it is blended with the normal system. This is what is called placement, layering, and integration. In PMLA, it is called PLI. So, what is an offense of money laundering? We are just going to discuss the two notifications which is impacting us, but some basic understanding it is required. What is a money laundering? What is offense of money laundering under the PMLA? Section 3 says, this is the definition: whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime. Crime means scheduled crimes, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted money shall be guilty of the offense of money laundering. Please look at it. See, whosoever directly or indirectly. Indirectly. What is this indirect involvement? It is not defined elsewhere. Everybody says that, no, see, this PMLA, it is a draconian provision. Many of the statements, many of the definitions are only subjective. It is not quantitative. So what is an indirect involvement in an activity, in a criminal activity, or in a scheduled offense? What is an indirect involvement? And that also, if you are, maybe you did not do that, but you attempted to do that. What is this attempt? Let us say the conspiracy did not actually happen, or the activity did not actually happen, but somebody attempted to do it. What is this attempt? It is not defined, it is not explained anywhere. There is no explanation with respect to indirect attempt, either directly or indirectly attempting. Attempting, it is not defined elsewhere. It is subjective. It is subjective. Let us say somebody, two persons, they are just discussing. They are just discussing something. They did not do any activity. No action has taken place. No activity has taken place. Could it be said to be an indirect attempt or just an attempt to do an activity? What do you say about? Can some of you comment on this? Sir? Hello? I hope there are somebody hearing me.
Yes, sir.
See, because the offense of money laundering, section 3, the definition it says, a person who is directly or indirectly attempting to indulge or knowingly assist or knowingly is a party. See, if you are knowingly you are a party, yes. If you have done an activity, yes. But if you are simply attempting to do something, what does it mean? The question is, if you are just discussing something, you did not do an activity, but you are just discussing something. So some person is coming to your place, no, so or coming to a place where some two persons are meeting. They are just thinking of doing something, just thinking, just discussing something. Can it be said to be an activity, an offense of money laundering? As per the definition, yes. As per the definition, yes. And for your sake of understanding, in section 24, I will show you section 24. There is something called presumption, or as we call it as the onus of proof. In criminal activities under CRPC and all, till it is proved, until proved guilty, the responsibility is on the prosecutor. Until it is proved guilty, that person is presumed to be innocent. So in a court of law, until the person, the so-called accused, is proved guilty, that person is presumed to be innocent. It is the responsibility of the prosecution to prove that no, he has done that offense. But under PMLA, it is ulta, it is on the reverse. I will show you section 24 later on. So if you are just attempting, it will be treated as an offense of money laundering. Then proceeds of crime. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. We have seen what is a scheduled offense or what is a scheduled crime. Or the value of any such property where such property is taken or held outside India, then the property equivalent in value held within the country or abroad. So from the activity that is listed out at the end of the statute in the schedule, you are earning money or that money is used for purchase of a property or some other article. Then the proceeds of crime means any property derived, obtained directly or indirectly by any person as a result of the so-called scheduled criminal activity. Suppose the property has been sold out or the money you have taken outside the country and you invested outside India. You are investing overseas. You are wise enough. You are not investing in India. You are investing outside India. Or you are purchasing a property outside India with the proceeds of crime. Then the value of any such property, where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. The question is, let us say if it is worth of 10 crores, now the money, the proceeds of the crime, it is 10 crores. 10 crores you have taken, you have repatriated outside India, you have taken outside India, you invested outside India. Now, if that is worth of 10 crores, then please look at the wording. Or where such a property is taken, held outside the country, then the property equivalent in value held within the country or abroad. Let us say there is another property which is worth of 10 crores, which is purchased not from the proceeds of a crime, but from legible money you have purchased. From out of legible money earned, you purchased a property worth of 10 crores or 20 crores in India. So to the extent of 10 crores, this property available in India will be construed as, will be treated as a property that is purchased from the proceeds of the crime. Since the proceeds of the crime, it is invested outside India. Now, this is also a very unclear subjective explanation. For the removal of doubts, it is hereby clarified that the proceeds of the crime include property not only derived or obtained from the scheduled offense. Scheduled offense we have seen, they have listed out, it is very clear, very specifically available at the end of the statute. Now there is an explanation. It says, proceeds of the crime include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. See the subjectivity that is involved, the lack of clarity that is involved. We have seen the scheduled offenses, the scheduled crimes listed out. And it says that if there is proceeds from the so-called scheduled offenses, that proceeds, maybe in the form of property or whatever it is, it will be treated as proceeds of the crime. Now they are saying that, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. So relating to the scheduled offense, relatable to the scheduled offense, there is some other offense which is not a scheduled offense. So relating to that what you call that relatable offense, proceeds are not obtained out of the scheduled offense. Proceeds it has come from some other offense other than scheduled offense. But this particular offense, which is not a scheduled offense, it is related indirectly, that is related to the scheduled offense, then these proceeds will be treated as proceeds of a crime. So directly that need not be out of the criminal activity or the offense that is listed out at the end of the statute. It can be from some other activity, offense, which is relatable to the scheduled offense. So it is anything under the sun, it can come. Anything under the sun, they can relate it to anything. That is what is actually happening. Schedule offenses we have seen. Schedule offenses we have seen. Now there is a concept called beneficial owner under the PMLA. Beneficial owner means it's in the case of a company, a person who is holding the shareholding of 25% or the voting rights of 25%. And for partnership and LLPs, it is 15% for the sake of understanding for the time being. Now we are coming to the most relevant topic, reporting entity. Because by these two notifications, we are becoming report entities, the reporting entities, chartered accountants, company secretaries, and the CMAs, we are becoming reporting entities if we are doing certain type of transactions as listed out in the notifications. Reporting entity, it is defined under section 21WA of the PMLA, where it says reporting entity means a banking company, a financial institution, intermediary, or a person carrying on a designated business or profession. So the catch, it is a person carrying on a designated business or profession. So what is a designated business or profession? We will have to see. As such, it's not an issue. But under designated business or profession, now we are also fitted in. Please see the rest of the contents. So reporting entity definition says a reporting entity means a banking company, so on and so forth, etc., etc., carrying on a designated business or a person carrying on a designated business or profession. So who is a person carrying on a designated profession or designated business? Now let us see. This definition, it is given under section 2.1 SA. Under 2.1 SA. The first 5 points, it has nothing to do with us. Nothing to do with we people, professionals. Now, person carrying on designated business or profession under section 2.1 SA. Person carrying on activity for playing games, running casino, etc. Inspector General of Registration, real estate agent, etc., etc. All the 5 points, let us say, just forget about the 5 points. Please look at the 6th point. Slide is visible, please. Hello. My dear friends, the slide is visible to you. Hello.
It is visible, sir.
Sir, please look at the 6th point from where the real issue, it starts from the 6th point under the definition part. Who is a person carrying on a designated business or profession under the PMLA? 6th point says person carrying on such other activities as the central government may by notification so designate from time to time. So the power it is given to the central government to issue a notification under section 2.1 SA. Power, they are getting the powers to issue the notifications from section 2.1 SA clause 6. Person carrying on such other activities as the central government may by notification so designate from time to time. So they issued the 2 notifications under section 2.1 SA by taking the powers of the 6th clause. This is the 3rd main notification. Let me read the notification first. In fact, no, see, we are not discussing the PMLA entirely. We are only discussing these 2 notifications and its impact on us, we people, how this is going to impact us. In exercise of the powers given by section 2.1 SA, we understood what it is. The central government hereby notifies that the financial transactions, this is very important. The financial transactions The financial transactions carried out by a relevant person on behalf of his client. Financial transactions carried out by a person, by a relevant person. Mind you that the relevant person is very important. There they are saying that a person carrying on designated business or profession. The section says person carrying on, the parental section it says person, parental section says person carrying on designated business or profession. It only talks about the person. Parental section talks about only person, not relevant person. But when it comes to the notification, when it comes to a notification is not a parent legislation, it is only a subordinate legislation. Subordinate legislation says the central government hereby notifies that the financial transactions carried out by a relevant person. Relevant person is not defined in the Parental Act. Parental Act, it only defines a person. Carried out by a relevant person on behalf of his client in the course of his or her profession in relation to the following activities: buying and selling of any mall property. The implication of are we buying and selling any property for our client? These questions we will address little later. So central government hereby notifies that the financial transactions, these are the listed out are the financial transactions carried out by a relevant person, mind you, relevant person, not person, on behalf of his client in the course of his or her profession in relation to the following activities: buying and selling of any mall property, managing of client money, securities or other assets, management of bank savings or securities accounts, organization of contributions for the creation, operation or management of companies, creation, operation or management of companies, limited liability partnership or trust, and buying and selling of business entities shall be an activity for the purpose of this said subsection. In fact, these are all activities done by the tainted chartered accountants, know whose names it has been referred to the institute. Now, we will analyze one by one, but please look at the entire notification. This is the first page of the notification. This is the second page. For the purpose of this notification, relevant person includes. The Parental Act does not talk about a relevant person, only the notification talks about a relevant person. An individual, relevant person includes an individual who obtained a certificate of practice under the so-and-so CA Act, an individual who obtained a certificate of practice under the Company Secretaries Act, practicing individually or as a firm, etc., an individual who obtained a certificate of practice under the Cost and Works Accountants Act. Lawyers are not included. Lawyers are not at all treated as a relevant person as far as the PMLA notifications are concerned. And for the purpose of this notification, fame shall have the same meaning as referred under the Income Tax Act. But the Income Tax Act does not define fame. Income Tax Act again says no, fame means the fame as defined under the Partnership Act. Now this is what the notification it is. Now we will go back. Now the legal circles, the legal experts, they say that in fact a parental legislation can define the terms, can define, let us say, the terminologies, but a notification cannot define a term as such. Here the relevant person, it is defined by a notification, not by a parental legislation, mind you. Person it is defined under the Parental Act, the PMLA. But this notification tries to define the terminology, the term relevant person. Now, it is when it is carried out by a relevant person on behalf of his client in the course of his or her profession, now in relation to the following activities. Now the question is, as part of our normal professional activities, are we buying and selling any property on behalf of our client? The answer is no. So dear friends, know what you say about, no, see, maybe you will be advising the clients to purchase the properties, we will be advising the clients to sell the properties, we will be advising on capital gains, we will be advising on reinvestment of the capital gains. All those things we will be doing, but as part of the professional activities are as permitted by our regulatory authority, we will not be we will not be doing the buying and selling of any immovable property for and on behalf of our clients. It is out of question. We are not doing that. So buying and selling of any immovable property. Managing of client money. Here the question it is, are we managing our client's money? Straight away the answer is no. One person who is a client of ours, for the payment of taxes, income tax or GST or whatever it is, that person is putting money into our bank account. That person is putting money into our bank account. That money is ultimately utilized for payment of the taxes, either GST or income tax or whatsoever, advance tax or whatever money it is utilized for payment of the taxes. And it is a routine activity for practitioners. Practice firms, this is a routine activity. Now, we may be maintaining a separate client account for receiving the taxes and paying their taxes. We may be maintaining a separate bank account. Maybe this is done by advocates also, maybe for payment of the court fees or payment of other charges, etc. Now the clients, they used to deposit money into our bank account and in turn will be paying the purpose for which it is received. We will be doing that. Whether that could be said to be managing of clients' money. This is where the question it is. Or this is what the question it is. Some of the legal experts say this could be said to be managing a client money because this is something done for and on behalf of the client. You are receiving the client's money and you are paying the client's taxes. This could be said to be managing a client's money because it's money of the client we are only managing. This is done for and on behalf of the client. What do you say about no? So please give me an opinion as to know what is your comment on this. Sir, please. From 3rd May onwards, we have this issue, whether the receipt of money into our bank account, from the client's bank account into our bank account, whether that will attract the provisions of notifications of 3rd May, managing of client's money. Can anyone comment on this? Hello? Hello? Can somebody comment on this? Rahman, how many participants are there in the platform? Hello, Rahman.
Sir, there are 40
Okay.
participants, sir.
So can, sir, the participants, can somebody unmute and tell me, see whether this buying and selling of managing of clients' money as referred in the 3rd May notification, whether it will come to us, whether it will attract our routine activities.
Yeah, one second, sir.
The third point is management of bank savings or securities accounts of the clients. When a practicing CA is doing these activities for and on behalf of the client, managing of bank savings or securities accounts.
Can you hear me?
Yeah, please.
Yeah. So the question is management. Definition of management.
Managing of clients' money.
Yeah. So management. What do you define? How do you define management? In that sense, do you have the decision-making ability to manage the funds on behalf of the client.
Yes, that's what exactly. You are coming to the core of the issue. You are coming to the core of the issue.
So if it is just for payment of some taxes, then you really don't have the ability to manage it, because you can't have any decision-making powers as far as that is concerned. So in my view, it should not apply.
Sir, I don't endorse the view that managing the client's money, the receiving the money into our bank account, then the onward remittance of taxes will attract the second clause of this notification. I don't endorse that view because it is just like a pure agency concept. You don't have the independent decision making as to what to do with the money. They are just entrusting you, just putting the money into your bank account for a specific purpose, and your role is limited to that of a pure agency in the sense what is received will be remitted with the authorities. Beyond that, you have no independent, let us say, decision making powers. Independently, you cannot handle the client's money, or the money that is deposited cannot be handled independently. So it is the role that is very limited. It cannot be said to be managing a client's money. You should have some leverage, you should have some liberty if you are managing that client's money. Cannot be said to be managing client's money. The receipt of the money into your bank account and payment of the taxes cannot be said to be management of client's money. But there are some other legal experts. They come and say that their opinion it will attract the second clause of this notification. Now the institute has to come out with a clarification on this, because we are all affected by this. There is no clarity as to what can be done, what cannot be done, whether this PMLA notification will attract the activities routinely done by us. The institute has to come out with a clarification on this, which we are all eagerly waiting. I don't endorse the view that it is managing clients' money. Sorry? Hello, sir, please. 4th point, it is 4th clause, it is organization of contributions for creation, operation or management of companies. Organization of contributions for creation, operation or management of companies. We'll come to that little later. Creation, operation or management of companies, limited liability partnership or trust, and buying and selling of business entities shall be an activity for the purpose of the said subsection. In the sense,
Krishna.
and relevant person, anyway, they say that whether there is a technical defect with respect to the definition of the relevant person, since it is not by the parental act but by the subordinate legislation. Some of the legal experts, they say that technically it is incorrect. It will not stand the test of law, but still it is there. See, for the time being, we will have to accept it. Till the time it is challenged in a court of law, the legal validity, we will have to accept it. Now, there is a 9th May notification, which is a kind of a clarificatory notification.
వీళ్ళు అప్డేట్ చేస్తారు.
9th May notification, it says, in exercise of the powers, again 21 SA 6, the following activities when carried out in the course of business. Here there is the wording of only business, there is no profession. It only says business. The following activity notifies the following activities when carried out in the course of business. There is no reference of profession. Here there is a reference of profession. Financial transactions carried out by a relevant person on behalf of his client in the course of his or her profession. In the course of his or her profession. Here the reference is only to business. On behalf of or for another person, as the case may be, an activity for the purpose of the said clause, namely acting as formation agent of companies and limited liability partnership. So when we are incorporating a company for a client, are we acting as formation agent of companies and the LLPs? In the second part of the notification, there is an explanation. Acting as or arranging for another person to acting as a director, or arranging for another person to act as a director or secretary of a company or partner of a firm or similar position in relation to other companies under limited liability partnership. Now please look at the explanation part. For the removal of doubts, it is clarified that the 9th May notification, they are saying for the removal of doubts, it is clarified that the following activities shall not be regarded as an activity for the purpose of 2(1) SA6. Any activity. Now, 9th May notification, it says, acting as formation agent of companies or limited liability partnership, acting as or arranging for another person to act as a director or secretary of a company or partner of a firm, etc., etc. Third is providing a registered office. That is very important. So in the earlier scam, where the chartered accountants were involved, for some of the companies, the foil companies, the shell companies, their own office, they have shown it as, the CAs, they have shown their own office as the registered office of the shell company. So the third point in the 9th notification says, if you are providing a registered office, the practicing professional, if he is providing his registered office, business address or accommodation, correspondence or administrative address for a company or limited liability partnership, then it will attract the 9th May notification. For this, acting as or arranging for another person to act as a trustee of an express trust or performing the equivalent function, etc., etc. Fifth is acting as or arranging for another person to act as a nominee shareholder for another person. Either you are becoming a nominee director, or you are arranging a nominee director for some of your clients. They become an activity by which you become a reporting entity. So please look at the explanation. We'll continue the explanation. So the following activities will not be treated as an activity by which you become a reporting entity. Clause A.
No.
Any activity that is carried out as part of any agreement of lease, sublease. Mr. Rahman. Hello, Mr. Rahman. So any activity carried out as part of any agreement of lease, sublease, tenancy, or any other agreement or arrangement for the use of land or building. Vijay Kumar sir, can you mute yourself?
I'm sorry, sir.
So any activity, now the notification says if you are providing a registered office, your practice unit office, you are providing as the company's office address or business address, accommodation, etc., etc. Here the clarification, it says any activity that is carried out as part of any agreement of lease, sublease, tenancy, or any other agreement or arrangement for use of land or building or any space, and the consideration is subjected to TDS under the Income Tax Act under section 194I of the Income Tax Act. Here the question it is, see what they have done it is, with the haste and hurry of bringing something into the PMLA net, they said, if a practicing CA is giving his office address as the company's registered office address, by doing that activity, you become a reporting entity. But if it is a third-party transaction, third-party to third-party transaction, if it is an arm's length transaction, now instead of talking about arm's length transaction, they said if it is a transaction on which section 194I TDS on rent is applicable, then it is outside the ambit of this notification. But 194I, for 194I to become applicable, the minimum monthly rent should be 20,000 rupees, or the yearly rent should be 2,40,000 rupees. So in an arm's length transaction where the rent amount is less than 20,000 rupees, it is third party to third party transaction, arm's length transaction transaction between unrelated parties. Now, because of the explanation that is given, explanation does not give exclusion to those kinds of activities. It only says for you to be outside the ambit of this notification, it should be an activity one which 194I is applicable. See the way in which the exclusion has been given. Can some of you comment on this? See, this is very usual, sir. See, practically, routinely, for many of us people, especially the all-time practitioners, for some of we people, when we take the registered address of some of our clients' companies, not so active operative companies, the registered office address is in the Chartered Accountants Practice Unit office. If that is the case by which you become a reporting entity, you will have to submit the returns to the PMLA authorities. Director FIU will have to submit a report, periodical report. Please take care. And the only transaction that is exempted, it is, instead of talking about arm's length transaction, now they are referring to 194I transaction where TDS has to be deducted. If TDS is deducted, then that transaction will be outside the ambit of the so-called given transaction as per the PMLA notification. Then second one, it is exclusion. These are the exclusions given under the 9th May notification. If it is carried out by an employee for his employer as a result of employer-employee relationship, then it is not considered as an activity by which you become a reporting entity. An activity carried out, the third point, it is very, very important for us. Are we agents in forming a company? The earlier question, it is acting as a formation agent of companies or limited liability partnership. 9th May notification, the first clause it says, if you are doing the activity as acting as a formation agent of companies or limited liability partnership. So who is a formation agent? If our role is limited to an activity that is carried out by an advocate, CA, CS or CMA who is engaged in the formation of a company, to the extent of filing a declaration as required under section 711B of the Companies Act, then to that extent, if you are doing only to this extent, if your activity is limited to this extent, you will not be treated as by doing this activity, you will not be becoming a reporting entity. Otherwise, yes. But the question it is, we are drafting memorandum and articles. We are putting up an application for availability of names. Now we do all what is required for a maybe given person or a person or a prospective entrepreneur. For that person, now what all that is required in our professional capacity we do. Hitherto that was permitted by the institute. So what is permitted by the institute, indirectly they are clipping the wings and they say that if your role is beyond this, you become a reporting entity. So to the extent of if you are involved in who is engaged in the formation of a company, and since you are engaged in the formation of the company, you are signing a declaration stating that these people, they have complied with all the provisions of the Companies Act. So and so. You are affixing your digital signature. To that extent, you will not be treated as a reporting entity. But beyond that, they are saying that yes, you are becoming a reporting entity. Any activity of a person which falls within the meaning of an intermediary, we are not intermediaries. So the first point and the third point, they are very important for us. If we are giving our office address as registered office address or the administrative office address or some other office address of our own clients, whatever it is, you should be very careful. Here and after, by doing that activity, you become a reporting entity. You will have to submit periodical returns with the PMLA authorities, Director FIU. Third is, in the incorporation of a company, the institute has to come out and give a clarification. In the incorporation of a company, if your role is beyond the third clause, by doing that activity, you become a reporting entity. Before proceeding further, Before proceeding further, if you have some questions on these two notifications, we will discuss, then we will proceed. Hello? Hello? Can you say something on this? It could be anything. Can you say something on these two notifications? Hello? Sir, can you comment something on these two notifications? Somebody was saying that no, they cannot unmute. Please comment on these two notifications, sir. Then we will proceed. I just want to hear from you.
So I gave access to all the members, sir. They didn't, they're not unmuting.
Sir, the time is not far away. Time is not far away. By doing certain of the activities, you will be put as a reporting entity by the PMLA, and the days are not far away that you could see a notice from the director FIU, not the director enforcement, but director FIU of the PMLA. So before that, please understand whether the activities which we are doing, hitherto what we were doing, whether that will fall within the category of the activities which they are talking about in the two notifications. And under the PMLA, there is a rule called maintenance of records rules. Maintenance of records rules. What is the importance of this particular set of rules? It is, if you are doing the kinds of activities as referred under the two notifications, by doing those activities, you become a reporting entity. If you are becoming a reporting entity, you will have to submit periodical reports to the director FIU of the PMLA. So once you submit the reports, the format of the report they have not brought in, they have not published, they have not announced the format of the reports. So because the hue and cry created, the ripples created by the issuance of the two notifications, these ripples are yet to settle down. Ripples are yet to settle down. So if you are becoming a reporting entity, by which reports are to be submitted, they are talking about the three categories of report. One, there is a report that is to be submitted within 7 days. Then there is another report which is to be submitted within 15 days from the end of the month in which the transaction has taken place. And the third one, it is a report that is to be submitted within 15 days from the end of the quarter. There are three categories of reports which they are talking about. If you are doing the so-called activities, by doing so, when you are becoming a reporting entity. Now, under the PMLA rules, the maintenance of records rules, there is something called something that is defined as a suspicious transaction. Please look at the definition of the suspicious transaction, which is very interesting. Now, by reading this definition, we will come to understand why people are saying that, or why everybody is saying that no, this PMLA rules are, or PMLA statute is very draconian. Because anything under the sun, enormous powers, unlimited, unrestricted powers are given to the PMLA authorities. What is a suspicious transaction? Means a transaction referred to in clause H. Clause H talks about a transaction. This is a transaction. Clause H transaction means purchase, sale, loan, pledge, gift, transfer, delivery, etc., etc. Opening an account, deposit, withdrawal, exchange, transfer of funds in whatever currency, etc. These are all called as transaction under the PMLA. Transaction it is defined. Now suspicious transaction means a transaction referred to in clause H transaction, including an attempted transaction, whether or not made in cash, which to a person acting in good faith. Now please look at the clauses, which gives rise to a reasonable ground of suspicion that it may involve proceeds of an offense specified in the schedule to the act, regardless of the value that is involved. So suspicious transaction means a transaction which gives rise to a reasonable ground of suspicion. Nothing it is quantified. Suspicious transaction means a transaction which gives a reasonable ground of suspicion. Now the fun it is, something that is interesting it is, if we practicing CAs, if we are becoming reporting entities, a reporting entity, if it comes across with a suspicious transaction, details about the suspicious transaction has to be submitted to the PMLA authorities within 7 days. Within 7 days. With respect to suspicious transaction, it is an instant report. And what is a suspicious transaction which is very subjectively referred, very subjectively. It is the lack of clarity, it is at the peak as far as the point number 1 it is concerned. What is a suspicious transaction? Is a transaction which gives rise to a reasonable ground of suspicion. This is the definition, that it may involve proceeds of an offense as listed in the schedule, or appears to be made in circumstances of unusual or unjustified complexity. We will put it into a practical situation. A new client is coming to our office. He is discussing about a project, discussing about an activity. He is a prospective entrepreneur. Maybe he is talking about the kind of money that he wants to bring in, he wants to invest. Maybe from some sources, or maybe from outside India, or from parties, whatever it is. Now, after discussion, we have a lot of apprehensions. Being a professional, being an experienced professional, we have a lot of apprehensions. Then please look at the point number A and point number B. So after discussion, it gives rise to a reasonable ground of suspicion that it may involve proceeds of an offense specified in the schedule to the act, regardless of the value that is involved. There is no material evidence that is required to suspect, or appears to be made in circumstances of unusual or unjustified complexity. You don't require any document on record, any material on record to suspect. So if you come across with any suspicious transaction, report has to be submitted within 7 days. Third point is, appears to have no economic rationale or bona fide. That transaction, that activity which you come across, the suspicious transaction which you come across, appears to have no economic rationale or bona fide purpose, or gives rise to a reasonable ground of suspicion that it may involve financing the activities relating to terrorism. So all the 4 points, if you look at, nothing it is quantified, nothing specifically that is available. It's all very, let us say, very subjectively they are stating that if it gives a reasonable amount of suspicion, unjustified complexity, or there is no economic rationale, or there is no bona fide purpose, then you will have to report it. Any of the participants, somebody wants to say anything on this? Sir. So if we become reporting entity, what all the responsibilities that we have? If we are doing these kinds of activities by which we become a reporting entity, what the reporting entity has to do? A reporting entity, maybe an individual practitioner or a firm of chartered accountants, which is a reporting entity, they are required to verify identity of the clients and beneficial owner by offline verification under the so-called procedure. There is something called an EKYC, e-registry, central EKYC registry, where you will have to verify the identity of the clients or use any other officially valid document or modes of identification as may be notified by the central government in this behalf. The provision casts responsibility on the reporting entity to identify beneficial owner as per PMLA. Now, beneficial owner means in the case of a company, that person is holding more than 25%, he is a beneficial owner. In the case of a partnership, if he is holding more than 15% of the stake, more than 15% of the profits, then he is a beneficial owner. LLP also same, 15%. So you will have to identify the beneficial owner. You will have to identify, let us say you will have to take the KYC. KYC has to be verified in this particular procedure. You will have to verify the KYC procedure. Then you will have to list out these things in the periodical report that is to be submitted to the PMLA authorities. This is what they are. This is the role that is responsibility that is entrusted on us by the PMLA notifications. If I move on and tell you the responsibilities that which are cast on us, responsibilities cast on us by this notification, now you will get surprised. Reporting entity will have to maintain records relating to transactions whether attempted or executed, the nature and value which may be prescribed for a period of 5 years from the date of transaction. It is very important. If there is a transaction as that of which we have seen in the notifications, the reporting entity, we people practicing CAs, FAME or individual reporting entity will have to maintain records relating to transactions whether attempted or executed, whether actually it has taken place or whether it is only attempted. If it is attempted, what is the document that is available? We don't know, but they are saying that if it is an attempted transaction, still you will have to maintain records with respect to the nature and value which may be prescribed for a period of 5 years from the 5 years from the date of the transaction between the client and the reporting entity. Let us say if the transaction has taken place from the date of the transaction, 5 years. The transaction has taken place, but the client is continuing. And the client relationship, it ends on a particular date. So from the end of the client relation, it is another 5 years, whichever is later. So first point, it talks about the reporting entity will have to maintain records relating to transactions whether attempted or executed, the nature and value which may be prescribed for a period of 5 years from the date of transaction between the client and the reporting entity. The nature and value which may be prescribed for a period of 5 years, that is yet to be announced, but it has to be maintained for a period of 5 years from the date of transaction between the client and the reporting entity. So the first is you will have to maintain the records relating to the transaction for a period of 5 years from the date of transaction. Second is maintain record of documents evidencing identity of its clients and beneficial owners, etc. For a period of 5 years from the date on which the relationship between the client and the reporting entity it has ended, whichever is later. So 5 years either from the end of the date of the transaction or 5 years where your relationship it ends later on. Let us say the activity that is carried out, transaction that has taken place on a particular date, but the relationship between the reporting entity and the client, it continues. So from the end of the relationship, it is 5 years, whichever is later. You will have to maintain the records enabling that people to reconstruct the transaction. That's what they are talking about. You should maintain all the records enabling the PMLA to reconstruct the transaction. Now, let me tell you what all records to be submitted to these authorities, the director FIU. The principal officer of a reporting entity. Principal officer of a reporting entity means if it is a partnership firm, the managing partner. If it is a proprietorship, it is a proprietor. If it is the LLP, the designated partner, the principal officer of the reporting entity shall furnish the information in respect of transactions referred to in clauses. These clauses are rule number 3. Rule number 3 talks about the various categories of transactions. Every reporting entity shall maintain the record of transactions relating to cash transactions of the value of more than 10 lakh rupees. These things are not applicable to us. Now, the transactions on which we will have to submit the report, it is the transactions as reported under the 2 notifications. Maybe the rule 3 is not applicable to us. So you will have to submit the report now every 3 months to the director by 15th day of the succeeding month. 15th day of the succeeding month. The principal officer of a reporting entity shall furnish the information promptly in writing or by fax or by electronic mail to the director in respect of transactions referred to in clause D. This is suspicious transactions. If there are suspicious transactions, now not later than 7 working days on being satisfied that the transaction is suspicious. The other one it is the principal officer of the reporting entity shall furnish the information in respect of transactions referred to in clause F every quarter to the director by 15th of the month succeeding the quarter. So what is this clause F? Clause F is purchase and sale of immovable property more than 50 lakh rupees. This is normally done by the registrar, the sub-registrar or the registrar or the inspector general of registration. So our catch it is the monthly report and the instant report that is required. Suspicious transactions when we come across as reporting entity within 7 days, and the transactions which are listed out in the 3rd May and 9th May notifications, it is within 15 days from the end of the succeeding month. And hitherto, after the 3rd May and 9th May notification, they have not brought in any specific format for reporting. Maybe some more consultation that is required, or institute has to come out with the clarifications as to what all it is permitted, what all not permitted. Now, let me discuss something that is very pertinent with respect to these 2 notifications and the Institute Code of Ethics. The Code of Ethics of the Institute, the Part 3, Professional Accountants in Public Practice. Now we are discussing only section 350 and 360. In the notifications, we have seen that now buying and selling of property for and on behalf of the client. They have referred it to buying and selling of third main notification. If you take the first point, it says buying and selling of any immovable property for and on behalf of the client. Now we are coming to the Code of Ethics of the Institute. Section 350 of the ICA Code of Ethics, Part 3, it says custody of client's assets. Now, what is this section 350 is talking about? This is what? A professional accountant shall not assume custody of client money or other assets unless permitted to do so by law or in accordance with any conditions under which such a custody may be taken. So normally, under the normal expectancy, under the normal practice, no practicing CA is permitted to take custody and control of assets of a client. Maybe that happens under the insolvency and bankruptcy code, where there is a resolution professional who is appointed. An insolvency professional is appointed by the NCLT as a resolution professional, then the resolution professional takes control and custody of assets of the corporate debtor. That is under the Insolvency and Bankruptcy Code. That is in his capacity as a resolution professional. There the regulatory authority is IBBI. It is not ICAI then. But under the ICAI Code of Ethics, for and on behalf of the client, a practicing CA is not expected to take custody and control of assets of the clients. So something that is prohibited by the institute. Now the PMLA says that if you are doing this activity, they are not saying that the institute has prohibited such activity, but they are saying that if you are doing that, which is basically prohibited by the institute regulations, if you are doing that, please submit the reports, the periodical reports. Second part, as part of client and engagement acceptance procedures related to assuming custody of client money or assets, professional accountant shall make inquiries about the source of the assets, consider related legal and regulatory obligations. So under the institute regulations, it is very specific. You cannot assume control and custody of the client's asset. That is point number 1. Point number 2, there is something called reporting to the concerned authorities about non-compliance of laws and regulations. That is referred under section 360 of the Institute Code of Ethics part 3. Responding to non-compliance with the laws and regulations, it is called a NOCLAR. This is applicable only for listed companies, but still it is there. 360 says is 360. When encountering such a non-compliance or suspected non-compliance, the accountant shall obtain an understanding of the legal or regulatory provisions governing such non-compliance or suspected non-compliance and comply with them, including any requirement to report the matter to an appropriate authority or any prohibition on alerting the client. So the Institute Code of Ethics, various sections of the Institute Code of Ethics, it says that you are not supposed to take control and custody of the client's assets. That is one. If there is non-compliance, deviations from the compliance of the law, you will have to, let us say, think of reporting to the concerned regulatory authorities. This is to a certain extent, this is addressed by the Institute Code of Ethics. But here the PMLA says, if you are doing these kinds of activities, whether it is prohibited or not under the institute regulations, they are not talking about. If you are doing these kinds of activities, then submit periodical reports. Before discussing further, no, sir, I would like to hear from you. Sirs, please. Please raise your general questions that need not be technical one. Hello. Can somebody of you share your general understanding? Rahman, they are all permitted to speak. No, they can unmute and speak. Hello, Mr. Rahman. Rahman, are you there? Now, let me take your attention to SA 250 also. 250 says, if the auditor concludes that the non-compliance has a material effect on the financial statements, and has not been adequately reflected in the financial statements, the auditor shall, in accordance with the SA 705, express a qualified or adverse opinion on the financial statements. So by SA 250 and Code of Ethics, Part 3, Section 350 and 360, to a certain extent, this matter it is already addressed by the ICI. But having brought in these two notifications by the PMLA in the haste and hurry of, let us say, making the entities, reporting entities, the practicing professionals, reporting entities, they are casting some responsibilities on the practice units. So many of the transactions which they are talking about, which they have brought in the two notifications, whether that will attract the normal routine activities will be categorized as those the routine activities which we are doing as part of our regular practice activities, whether that will be categorized as, mentioned as, or fitted in as the activities as referred in their notification, it is yet to be seen. We are waiting for Institute to come forward and give some clarification in writing. Now, initially I spoke to you about the burden of proof. Burden of proof, it is very interesting. Even in a criminal offense, until the person, the so-called accused, is proved to be guilty, the presumption is that that person is innocent. It is the responsibility. The responsibility is on the prosecution to prove with corroborative evidence that the person has committed the offense, maybe with the witnesses also. Till that is done, the presumption is that that person is innocent. The benefit of doubt, it goes to that person. But in the case of PMLA, section 24 of the PMLA, I am just reproducing, in any proceeding relating to proceeds of crime under the Act, in the case of a person charged with the offense of money laundering under section 3, the authority, the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. In the case of any other person, the authority or court may presume that such proceeds of crime are involved in money laundering. In one of the recent cases, somebody went to the Supreme Court and they pleaded that this particular section 24 of the PMLA should be deleted, should be quashed. But the court refused to do it. They said it can be there. It can be there. They can continue the proceedings under the PMLA. So as of now, section 24, it has got this legal sanctity. So these enormous powers, they are deriving from various sections, including section 24. In the case of a person charged with the offense of money laundering under section 3, it is his responsibility, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. So only an allegation that is required from their side. That allegation, unless it is proved on the other side, unless it is proved otherwise, that person will be treated as a guilty person. Or in the case of any other person, or in case of any other person, the authority or the court shall may presume that such proceeds of crime are involved in money laundering. So, Mr. Arun, I presume that you are there.
Yes, sir.
Welcome.
Just now I joined, sir.
Oh, welcome. In fact, I will conclude within 10 minutes, but I would like to hear from the participants something.
Sir, if there is any query from the participant, we can have that thing, sir.
I can unmute and speak now.
Sir, my unmute only, sir. My thing is only on unmute only, sir. Now it is audible, sir.
Yeah, audible.
Yeah. Rizwan, unmute everybody. If those who are all having any queries, they can unmute themselves and ask the query to the speaker.
Arun, I would like to see your face now. Please switch on the video. Yeah.
Because I am not in a formal, that is.
Oh, no issue. You are in Salem now?
Yeah, I am in Salem now.
Okay. Participants, no, please interact now, sir. Please interact. Anything which you would like to ask, no, please ask me. If I can help you, maybe with a little what I know. Yours, sir, please unmute and speak. Hello.
Chat box says somebody. Huh? Sir, some questions are there in the chat box. Na, sir.
Can somebody read it?
Raghuman or Rilwan, who is there? Anybody is there? Because that is not, because I've joined later now, that questions are not in my chat box. Otherwise, I'll read it.
So chat box la போட்டுருக்காங்க சார். ஹலோ கேக்குதா சார்? அருண் சார் கேக்குதா?
Yes, yes.
George Kora sir says no, he is not able to unmute. Can somebody unmute him?
Give access to all.
I think some technical glitches. It is not. They are not able to unmute the things. Rilwan.
சார் இல்ல அவங்களுக்கு ஆக்சஸ் கொடுத்துறேன் சார். அதை ஏன் அன்மியூட் பண்ண முடியல தெரியல.
But even my partner says it is not. I am unable to unmute.
1 second சார்.
Couple of points, if you can hear me.
Yeah, please,
Okay,
sir.
one was in that one of the slides you did mention about a trustee also. So what happens if you are a trustee in a public charitable trust? Do you become a reportable entity?
You are a practicing professional. You become a trustee. Or you are arranging a trustee for a trust. And by which you become a reporting entity.
Yes. If you are in so a chartered accountant who is a trustee will therefore become a reportable entity.
Yes.
Okay. However, as you say, right now, notification is not there in what format it has to be reported.
Yes. They have not brought in the format of the reports.
Right. The other thing is with regard to lease of property, if you do want to lease, you say that unless TDS comes into play, only then will it, it'll escape the net. So you were talking about if the payment is below the threshold of 20,000 rupees per month or 2,40,000, it becomes a problem. People can actually deduct, even if it is say 10,000 rupees, you still can deduct the TDS, even though it is below threshold. So on that basis, provided the lessee also agrees to that, and then you can probably get out of that. Your thoughts on this?
The clarification, the exclusions which they have referred in the 9th May notification. So the intent of the notification should have been to exclude genuine third-party transactions or maybe arm's length transactions. There is no intent that is involved. You being a chartered accountant, maybe the client is a company. You are involved in the incorporation of the company. If the company is incorporated, after the company is incorporated, let us say you have a property where your practice unit is separated altogether in some other location, where you have a property, you are letting out that property, and there is no interest that is involved. It is not a related party transaction in the sense arm's length price, it is basis, it is arm's length price, it is applied. But the rent, it is, let us say, 18,000 rupees. By 194I provisions, still you can cut the TDS, no, that is altogether a different issue. But by income tax provisions, which does not warrant you to deduct a tax because it is less than 20,000 rupees monthly or less than 2,40,000 rupees yearly. So if they say that no 194I should be applicable on a transaction to get it excluded, that seems to be illogical. What they try to apprehend it is, or the kind of transactions which they intend to apprehend it is, maybe you are creating a company, you are involved in the incorporation of a company. Now, after incorporating the company, you are there in the forefront, and your own office, it is shown as the registered office address of the company, and you take a lead role in running the show. In those cases, maybe they wanted the reporting entity to report. But the only exclusion, it is 194I transactions, so that seems to be maybe an illogical exclusion.
Right. Thank you so much.
Yeah, welcome, sir. The most important thing, what I understand, it is not if they are treating the money that is coming to our bank account for payment of taxes, if they treat it as the managing client's money, then 95% of the people will be put in trouble. This has to be addressed first. The institute has to come out with a clarification. I don't know
Sir,
what you think.
unless otherwise we are using their account and transferring, we are involving those activities. How can they prove that we are managing their money, sir?
Yeah, that's what, because I don't see, I already mentioned, I don't endorse the view that these receipt of money into our bank account and payment of taxes, no, per se, that cannot be said to be managing the client's money. But some of the lawyers, unfortunately, some of the lawyers are of the opinion that it is managing the client's money. Here the question it is, no, George sir also raised the same question. Do we have a decision-making power with respect to that money that is coming to our bank account? No, it is just like the pure agency concept in GST.
Yes.
Just receiving and making payment.
Yeah, unless otherwise we are not involving their money management and all. No, only maximum our involvement relating to only receiving the money for tax payments.
But see, even in SARC, no, before this presentation, sometime back there was a presentation on this topic. I have listened to the speakers, and one of the lawyer was opining that no, this can be fitted as, this can be treated as managing the client's money, because this is money that is received. You are doing this for and on behalf of the client, so it will attract the provisions of this notification. No, he was opining that. I don't know how this will turn around.
Any quantum is there, sir, to taking the ED, the thing, other things and all? It is any quantum is there?
It is category wise. Let us say for suspicious transactions, no, there is no limit. For other transactions, if it is cash transaction, 10 lakh rupees. And we as practicing professionals, we are concerned with only certain limited categories of transactions, in the notification. Notification is not exclusively for CS, but we are also brought in under that ambit. But whether, see, it is not the question of reporting, let us say, for the let us say there is a default in reporting. Unlike GST and income tax department, let us say tomorrow if the PMLA authorities, they are issuing a notice on us and we will have to go there and face the, let us say, the hardship of facing those people. If you have to undergo that, no, see, you will be put in trouble.
Correct.
See, for the reason that, no, for the sin that, no, we received 50,000 rupees in our bank account and paid the taxes. Indirectly, we are only facilitators. We only helped the government in collecting the taxes. For the reason that we are helping the government to collect their money, if you are taken to task and we are grilled by the PMLA authorities, just imagine the situation.
Yes, sir. Even loan syndication and all, now it is a difficult job now. When we involved in any loan syndication things, they maybe bring under this PMLA thing now.
The scope that is given, see, before you coming to us, no, see, we were discussing about the scheduled offences. If the money that is received from scheduled offences or any activity that is related to scheduled offences, any activity, see, even a simple stealing of something, let us say, some small offense, a small crime that is happening elsewhere, that can also be a reason for enforcement directorate, the PMLA authority issuing a notice.
Correct.
Bribe is also a scheduled offense. Bribe is also a scheduled offense.
Correct.
So if there are no other questions, we will wind up.
Yeah, sir. Members, is there is any question is there?
Some of the members, they were saying that, no, they were not able to unmute.
Sir, he is asking the question now, sir. George sir only asking the question. Actually, he only says can't unmute. Then he unmute and ask the question.
Okay. And another very pertinent question which members they used to ask the whenever there is this matter that is discussed elsewhere, one question that members they used to ask whether a nil report that is required, for which also there is no clarity now. We are not doing any of these activities. No, so we are not into these kinds of activities, these kinds of transactions. The question it is basically by the notification itself we become reporting entity. So being a reporting entity, whether a nil report that is required. Even the PMLA authorities, they are also not replying to this particular question. They have no clarity as to whether nil report that is required.
Okay, shall we close, sir?
I think no, we'll close. So thank you very much for giving me this opportunity. It is always a pleasure and privilege standing on the SIRC platform and speaking to the members. My heartfelt thanks, sincere thanks to Mr. Arun and all the officials of SIRC for making me speak to you. Thank you.
Sir, thank you, sir. Thank you for accepting our invitation too and presenting the paper on PMLA. Actually, everybody is having some doubts about what to deal, what to not to deal regarding to that client things. Sir. I think the members get a clarity on few points. Sir. So thank you, sir, and also thank the participant and other office bearers who are supporting this thing. Thank you, one and all.